Hello, everyone. Thank you for joining us for another version of our free education series. This one is sponsored by the American Optometric Association. We are proud to be the endorsed solution by AOA Excel for the eye care market. This webinar series this particular webinar as well as our other webinars are recorded and available on our website. So please feel free to hit up our, go to our website, download. There's lots of great content. Today we're going to talk about audits, but we have other ones on HIPAA compliant marketing, cybersecurity, etc. So there's lots of great topics to help you run your practice more efficiently, etc. There is a series of free resources available on our website, so please do make use of it. And as well, through the AOA website is our Ask the Auditor function. So whether you are a client or not, you are welcome to come and ask us questions in regards to compliance, and often cybersecurity has been a big topic for everyone. So for today, we're going to be talking about audit tips that every OD should know. Okay, because what happens is, although we hope that you won't be getting audited, there is definitely a chance, and I'm going to talk a little about the odds of you getting audited, some of the things you should expect in the case of an audit, and then some good common sense, basic things that you can be doing to protect your practice. As we go through the webinar today, please do ask questions. I will do my best to get to them. If we do run out of time or there's a question that is kind of more complex, myself or someone on my staff will get back to you. So let's take this a little bit. Now, I am Mark Haskelson. I'm the president of Compliancy Group. As I said earlier, we are the endorsed solution by AOA Excel for HIPAA compliance for the optometric community. We are also proud to be sponsors of Think About Your Eyes. We think that's a great program for educating people on why they need to come see you for eye exams. And then lastly, we take our relationship with eye care very seriously. I am a fourth-year visionary level contributor to the AOA Political Action Committee. The world of compliance and cybersecurity are very much hand in hand. So we also take a very dominant position as being on the advisory board and head of many of the councils for what's called CompTIA. And this is the organization that does all the certifying of what is the IT techs you come see you. Now, although we do love the world of eye care, it is one of my favorite markets to be in. We are also endorsed by 40 other medical associations, most of the technology providers, hosting services, EHRs, medical applications, IT providers, consultants, etc. are either using our technology or recommend our technology to their clients. All right, so now that hopefully I've proven to you that you should take what I talk about today seriously, now let's start talking about the issues. So the first couple of minutes I want to talk about is what is the misunderstandings, what's required, what's not. Then I want to step into what are the benefits of being compliant. So although we're going to be talking about auditing, this isn't just when you get audited, can you defend yourself? There are lots of great benefits you will garner, things like patient loyalty, increased conversion off your website, that can ultimately be tied to the more HIPAA compliant you are. So let's start off with the big fear. Okay, if you are in there is something called the HHS Wall of Shame. Okay, and what that translates to is any breach or incident that occurs in the United States, it's mandatory you report it. And if you report it, those audits are going to be, or those breaches are going to be public record. Okay, and it's called the HHS Wall of Shame. And if you Google it, it's the OCR, and I forgot the exact URL, but if you Google HHS Wall of Shame, you will find it. Now, what I want to point out about these things, a couple of things. First of all, there are currently 36 open eye care breaches, of which there are 13 that are considered meaningful breaches and under investigation for negligence. So the belief that this isn't happening in eye care is a false assumption. Okay, it is happening just as much in eye care as it happens in any of the medical specialties. I do think there are, as we talk about the value or benefits, one of the big things I think is different about optometry is that understand that your clients look much more like consumers. You know, they are purchasing, in some cases, optional things. They look much more like you function much more as like a retailer to them. So let's talk about, when we talk about the Wall of Shame, what that data point was really telling us, okay, is that Much of what causes the incidents or breaches and the audits that you have to be concerned about are predominantly caused by human error. Okay, so for example, 59% of the issues are simple theft. Okay, 1 in 10 smart devices will be lost or stolen this year. Okay, which means if you have 10 people on your staff, I can guarantee you will have one incident that should be reported and therefore will result in you being involved in at least one audit. Okay, now the rest, which is kind of interesting, is most people presume that the majority of risk had to do with hacking and ransomware. Yes, it is true. 88% of ransomware is aimed in the healthcare market. But the other thing you have to worry about is the vendors that you work with. 30% of all breaches actually originate from the vendor who is serving you or providing services to you. Okay, so presuming that they're protecting you is a bad assumption. So now let's talk about the random odds of all this. When I talk to a lot of people, they play lotto every week. They won't swim in the ocean. They run inside when it's raining. They will play golf, every weekend, 3 times a weekend to try to get a hole in one. Yet when you get down to the chances of you being involved in a HIPAA or a meaningful use audit, they are actually, if you combine the two, 1 in maybe 300-400. Okay, which means if you look around the room and the next event you're at, the next optometrist meeting or a regional event in your state, it means that there's going to be a couple of you in that room that this year are going to be undergoing audits. Okay, so the point I want to make to you is not to be scared of that, but to understand what's involved in that and how you can protect yourself, your patients, your families, your good name. So let's talk about what causes a HIPAA audit. Okay, there are really 5 key reasons that will cause an audit to occur. One is a breach. If you have a breach, whether it's the loss, a faxing of something to the wrong location or a lost device, if it is a meaningful breach, notice that potentially, notice I said potentially, more than 500 people could be affected, then you are mandated to report that incident within 60 days to the U.S. government. Now, what I will tell you, when you report that, you will be getting an audit. Okay, what level of audit I'll talk about shortly. Now, when I was illustrating the wall of shame, since 30% of the breaches or security issues that occur are caused by the business associates that serve you, the next thing you got to worry about is the fact that your business associates may get you, your IT company, your EHR, your billing firm. Any one of these organizations can have an issue, which will then cause you to have a meaningful breach, cause you to be pulled into an audit. The next thing is what's called phase 2 random audits. Although the laws and the enforcement rules changed in the period from the end of 2013 to 2017, one of those items were that now the U.S. government has the right to randomly audit anybody in healthcare. Okay, which means you could have done nothing wrong, but you're going to get a letter that says, hey, we just picked your name out of the hat. We want to find out what you're doing. Now, the next one is meaningful use MACRA-MIPS failures. Do you understand that there's a mandatory 5% audit of all MACRA-MIPS? I know some eye doctors that have been audited 3 times for MACRA-MIPS. If you are audited for MACRA-MIPS and you fail, i.e., and the number one reason for failing is that most people will do a security risk assessment, but fail to do the rest of the required audits. And I'll talk more about what that means and how it relates to healthcare. But although they are 2 separate organizations, it is pretty much government policy. If they consider you having taken money from the U.S. government and not being properly compliant, they will turn you in, and then you will have another HIPAA audit. The last thing is a reported or whistleblower or complaint. A lot of people believe, a lot of eye doctors I talk to believe that it has to be a patient or an employee for someone to report you for a HIPAA audit. That is not correct. Okay, the way the law is written is anybody could walk by your office, they could look in, and if they felt that they could look over the shoulder of somebody at your receptionist at the front desk, and they felt that there was a HIPAA violation, they have every right to report it. They get to report it anonymously. And the real kicker here is if it was considered fraud, waste, or abuse, i.e. that there was monetary negligence involved, whoever filed that audit, whoever reported that technically gets a piece of whatever money is required. Okay, so there's some strong motivations as to why they want to make this, they'll want to report. Okay, so now the unfortunate reality is you have an audit. Whatever was the cause, here is what happens with audits. People don't show up with guns and badges. What you get is a certified letter that's going to give you 10 business days to respond back with some information. This is what's called a desk audit. Okay, so normally, let's say the first things they request are things like your gap and remediation report. Remember, and I'll talk a little about the law, the audits that are required to be done every year, and the fact that you need to store that data 6 years back says it's very simple for an auditor to say, we would like to see 2016's audits. Show it to us and show us the remediation efforts you did and how you did them, okay? Now, if they like what they see there, often auditors will move on, okay? Remember, they are trying to find people who were grossly negligent, okay, who had misconduct, that kind of thing. So if they don't like what they see, they will then go one step further, and that is they are going to come on site and they're going to truly review what is called the 7 fundamental elements of an effective compliance program. I'm going to talk more about what that is, and that's where they start getting much deeper into, is what you are doing effective based on your size and scale as to what you do. Now, either way, through any one of these audits, one of 3 things can happen. They look at you and they say, we think you're all set. We don't think you have any issues here. By the way, this is one of the things that I find a little bit of another misunderstanding. There is no certification by the U.S. government. There was no there was no certification that you're going to suddenly be deemed compliant. As a matter of fact, it's even a misnomer that you are ever 100% compliant, because there's always dynamic things that are happening in an organization. Okay. Next thing that happens is, so if you were deemed to not have any issues, great. Now, what if you were deemed to have challenges? Okay, and I'll talk a little bit when we get into the fines, some real stories of doctors that we're working with in the eye care market, and the fines they have had, or I'm sorry, the challenges they've had and the fines that they could have potentially been subject to. Now, so step 1, you could get fines. Average fine is $1.5 million. They can be larger, they can be smaller. But the average fine currently is running at $1.5 million. There is a common set of themes that people are getting audited for, and I'll talk more about that as we get deeper, okay, or what they're fined for, I should say. Corrective action plan. What that is the U.S. government has looked at what you did. Whether or not they find you, they have defined that you are weak, and they have asked you to create a plan showing how you're going to fix the areas that you are insufficient in, and then they are going to define how often they come back to look at you. Okay, that's a scary thing, 1, because of the cost and effort in supporting it, but 2, it means the auditors have a chance to come back and look what you did over and over again, all right, which ultimately can lead you into more and more trouble. Now, usually one of the other challenges for the process of an audit is you usually have 10 business days to respond, which means if you do not have your information well organized, it's going to be very hard for you to be able to provide the content and prove your compliance. This is one of the areas we see as very common failures for folks in the audit when they get audited. Now, next up, let's talk about what are those 7 fundamental elements I referred to. Okay, so this is the federal guidance. HHS, Health and Human Services, that's the HIPAA police, and the OIG, the Office of Inspector General. These are where auditors come from, got together. Believe it or not, I don't know why the market has not been more aware of this. This federal guidance came out in 1996 when the law first came out, okay? And what it says is that one of the problems with HIPAA law is it is a gray law, which means, what I mean by that is the same law and the same set of requirements apply to you whether you are a solo independent optometrist with 3 employees, or whether or not you're one of the big private equity roll-ups or one of the big retail chains, okay? So what is considered effective is relative to what you do as a business, okay? So let's talk about what are the minimum requirements and then ultimately what's considered effective. So the minimum requirement, step 1, is you have to have written policies, procedures, and a standard of conduct, okay? So the idea of having a staff meeting and talk about things, that does not satisfy the federal regulations, okay? 2, somebody at your office has to be a compliance officer, or there has to be somebody responsible for managing this. And I'm going to give you my Starbucks example in a minute, okay? Now, now the next thing has to do with training, lines of communication, and internal monitoring and auditing. Now, what is effective for one organization might not be effective for another. Okay, so for example, having training done once a year by an outside organization, if you are a solo practitioner that has, the same 5 employees and has for the last 10 years, then that's absolutely effective. But what if you're a large growing practice, which means you're hiring, new people every month? Then that training you did in let's say August, you might have a whole group of people that were not trained at all for what could be a year or more. So those are the issues that you have to make sure that you are addressing. Now, enforcing standards through disciplinary guidelines. It is not acceptable if you say, yeah, we got rules and they're really important and everybody follows them. Okay, prove to us that if they don't follow them, what are the repercussions? Will they lose their job? Will they be suspended, etc.? And by the way, that has to apply, yes, everyone from the doctor who owns the practice all the way down to the janitor if there is one. Okay, now the last part has to do with what's the breach notification rule, which I'll talk about more in a minute, and that is you must respond promptly. In the case of a meaningful breach, you must respond within 60 days. If you failure to do so, is considered breaking the law, and then you have to have corrective actions about what were the things that you identified. So the reason I use my Starbucks example here is, if we were in a live room, I'd ask you to raise your hand and tell me how many of you spend an extra, $18 for a cup of coffee. But the reality is, what is effective compliance? It's a differentiator. And the Starbucks example, or we can use other brands that are highly respected. And that is, when you walk into a Starbucks and you order your caramel, non-fat, diet macchiato, whatever, okay, here's what really happens. They have a very specific set of policies and procedure, and the code of conduct, the smile they have to give you, the asking for your name. From there, then there's a manager whose job is to make sure that people follow those policies and procedures, exactly how hot a cup of coffee should be or should not be. Okay, you have very specific training and education to make sure everyone understands what needs to be done. Lines of communication. Hey, as you are changing in the new cups of coffee come out for the fall, that pumpkin spice latte, someone's explaining that, and those training and education goes with it. Now, that monitoring and audit thing. Is there somebody, in this case, a manager or a supervisor, is making sure they're walking around, there's little temperature sensors you see, little alarms going off, so they're monitoring to make sure that cup of coffee is the right, not too old, not too hot, not too cold, etc. If you don't do it correctly as a barista, you might be suspended, you might be fired. And then lastly, when that happens, those offenses are very quickly reported back to senior management to decide how to address. So that is the exact same thing as HIPAA compliance. What I can tell you, this can have a profound effect on patient loyalty. Why? Let me give you an example. Patient walks in, one of the 2 very common ones we see is, it is a child that has now turned 18 and the parents are coming in asking for records, or it is an elderly patient and their child has come in asking for something about their healthcare. Now, the question we often get asked is, what are we allowed or not allowed to do? Now, if you had good policies and procedures in place, your staff would know exactly what to do. Your patient's experience or the patient's representative experience would be very well defined. You would have very clear codes of conduct as to how quickly things have to be responded to, etc. So it gives you not only better patient loyalty, it also tends to improve your employee satisfaction. Why? People don't like question marks. They like organization, and they like to know that that it isn't going to be subjective on how they're going to be to treat people or how they are going to be treated themselves. Let's see. Sorry, there was a question. Okay, so what I'm going to do, thank you for this question. I'm going to hold it off for a little bit later because I think this question I want to address for you more globally. So let me continue down. But thank you guys. Please do start asking questions if they're related to the slide I'm talking about or the specific question that was posed here. I want to answer in a little bit in a few minutes. I think it'll be more informative for you. Okay, so let's talk a little bit about real live stories and how breaches and/or fines could have been avoided. So there was an organization happened to have been in Alaska, they were a behavioral health group, so a smaller organization, 30 employees, right? So, on the bigger side for the average eye care, maybe not. Okay. The problem was they had a malware issue. A malware is ransomware, an email, virus, etc. Because it affected more than 500 people, they reported it. Now, the where they got into trouble, okay, was not the fact that they had a malware attack. It was the fact that when the auditors came in, they asked for some basic things, going back to that, what happens in the process of a desk audit. Okay. First of all, show us the audits that you did and how and did you do all of the required audits every year going back 6 years. So first off, they had done security risk assessments. They did not have the other required audits. I'll explain what those are in a minute. They did have policies and procedures. And by the way, store-bought policies and procedures, there's nothing wrong with that. The problem is if you just buy policies and procedures but do not modify or correctly make sure they adjust the way you run your practice, then you do not have effective policies and procedures. Especially because if they didn't properly reflect the way you run their business, then they're clearly not going to help you protect your patients and your employees. The last thing was training. Because this was an organization that had very high turnover, the once-a-year training was considered ineffective. So even though the fine was relatively low because they were a nonprofit, ultimately the impact of here is a pretty telling example that when I walk into most doctors' offices, this is what I get told. We have, no, don't worry, we did a security risk assessment. We downloaded policies and procedures free from one of the state associations, and we do training. Lisa does training at the staff meetings once a year. Sorry. Important, valuable, we appreciate your effort, but you are not HIPAA compliant and you absolutely would fail an audit in the case of if you were audited. So there's a bunch of big misunderstandings we see. The largest being that compliance and security are the same thing, of which they are not. The next thing that comes up is people refer to what is the high-tech rule, presuming that it is and the macro MIPS implications of it, that's all one thing, and if I did my security risk assessment, I'm in good shape. We also see a lot of misunderstandings around what is the omnibus rule. So let me explain how this works, okay? So the privacy rule has been around since 1996. It has always said that you as a covered entity, you as a doctor's office have some responsibilities about the way you communicate with your patients. Not allowed to yell information across a waiting room. Don't talk about them in the lunchroom, etc. Okay? Where a lot of people got into trouble in today's world was the misunderstanding of the security rule. Okay, the security rule is not a security risk assessment. It is actually a definition of what is 6 required audits. One is this, 2 of them are the security and technical audit. The confusion that has most often occurred here is that is the same language as what is macro MIPS meaningful use. But remember, macro MIPS meaningful use is a new program. They presume that you would always, since HIPAA has been around since 1996 and always required these audits, the presumption was it was no burden on an organization to ask them to provide the audit that they were supposed to have anyway. Now, what people then forget to do is deal with what is the physical audit and the administrative and privacy audits. Those are equally important. Okay, last thing is the omnibus rule is really 2 different rules. Okay, one is the breach notification rule. The breach notification rule, pretty straightforward. Incident or breach occurs, you have 60 days to report that to the US government if it's meaningful. Meaningful means more than potentially 500 people affected. By the way, I'm going to stress potentially again, because it doesn't have to be that it was actually 500. It was, so a stolen smartphone, 1 in 10 gets stolen every year, would be considered a meaningful breach because they could have access to your EHR or to your other records. The business associate relationship. Okay, because 30% of breaches were caused by BAs, now you have a situation where the business associates are responsible because they caused so many of the breaches. You have an obligation that before you share PHI with somebody, you must do what's called, you have to do 2 things. You have to have a business associate agreement in place, a BAA. That's a legal document that says, you're not responsible for their HIPAA compliance. You're responsible for having a document that says, hey, we both understand we fall under the law. I'm responsible for what I do. You're responsible for what you do. Now, the second component of that is before you share your information, the PHI, protected health information, with an entity, you must make sure that you've done a technical due diligence. Okay, that can be minor or major depending on what data you're sharing and how complex, but either way, you have to make sure that you've confirmed that these people can protect the information they're working on. So for example, if you let a billing person work for you after hours in their basement, that's usually not a very secure environment, but it might be, right? It really depends. So you need to ask some questions and make sure you have documentation to back it up. So let's talk about the required risk assessments. I think we've just in general understand that there are 6 that are required. If you are not doing all 6 every year, you are breaking the law. Okay, and out of all the things that happen, every single fine that has been levied is predominantly 3 things. It's always failure to do adequate risk assessments, failure to have proper policies and procedures, and then the third one is having business associate agreements in place. So what that looks like, often what we see is people do what I would call HIPAA light. They address the security components pretty well, but they neglect to address the rest. Okay, so now not only are you leaving a monetary risk to yourself and from a liability perspective, but these are things, as I stressed a little earlier, and I have a whole webinar on patient loyalty and HIPAA compliant marketing. Not being HIPAA compliant, not doing what is required, you're going to leave your prospects frustrated, right? Your patients are going to be, why should I go to you if I can go somewhere else? Now, what is HIPAA done right? Now, today is an educational session, but I'm going to start stressing about why the AOA has endorsed Compliance Group to be the solution is because we address all components of the law. But now let's talk about what's required. Okay, so first off, the 6 audits that are required must be done every year. You must have written gap identification and written remediation of those gaps identified. Okay, usually what we see is about 15% of them are security related. The rest are going to be policies, procedures, and training. So it is not sufficient to we have a security policy. Okay, maybe we got that from our IT group. That's fantastic. But you must have all of the policies and procedures in place and all of the correct training. Now, the next thing, there are some little gotchas from the US government. They're afraid you did this once 12 years ago and never updated it. So they ask you to prove that you reviewed your documents on a regular basis, in this case, every year. Okay. The other thing they ask for is employee attestation and verification that your employees have legally agreed to follow what you do. So in this case, I'm going to use, for those of you who may be PERC members, Dr. Golden is one of our clients. He talks about a situation where one of his staff members, it was an IT person, they basically did not do what they were supposed to do. So when he had a massive breach and had to report it to the US government, the fact that we could prove to him that employee, to the government, that employee had actually attested that they were going to follow a set of protocols and that they individually chose not to, the liability was on the employee, not on Dr. Golden's practice. Okay, business associate management. We talked a little bit about that. You must have BA agreements. You must have contract management, show when they were signed and when they will be reviewed on a regular basis, which is usually annually when they expire. And then your technical due diligence. The last thing that's required on being truly both secure and compliant is your incident management and remediation tracking. Whether you do it in an Excel spreadsheet or you use a tool, you need to be able to prove that you investigated it, that when you're done investigating it, you remediated the gaps, and that you reported correctly to the US government what occurred. That is HIPAA done correctly. Okay. Now, by the way, on this one, if you are approached by any vendors that can say to you, hey, don't worry about it, you can just do a quick checklist, 20 minutes, a half hour, 45 minutes, an hour, whatever it is, understand you are addressing pieces of the law, and because you failed to address the rest, you are negligent. You went from being what was a potential $100 per incident fine to being $10,000 to $50,000 per patient record because you just did that security risk assessment and didn't address the rest. So now let's talk about some real live examples, okay? And these are different. I've chosen to try to pick up different ones that could potentially happen in any practice. Patient testimonials. Patient loves you. They gave you a nice letter that they expounded upon how great your practice was. You thought it was a nice idea to put it up on your website, but you never asked permission. So in this case, it was a physical therapist who did that. Ultimately, it was considered a HIPAA violation. It was a $25,000 fine. Okay. You did something really, really good, with one of your patients, maybe something bad. In this case, this was in the state of Texas. There was a regional organization that was actually a regional hospital. Someone came in for a medical procedure. They were perpetrating fraud. It was not legitimate. So the hospital was very proud of the fact that they caught them and prevented that from happening. The only problem was they used the person's real name in the procedure that they came in for. That was a HIPAA violation, $2.4 million fine. Late breach notification. So anybody who tells you that you don't need to be worrying about all these things is entirely incorrect. If you fail to report a breach, in this case it was a surgical center, they just lost not the patient's full records, just the surgical schedule for a day. It was later found, because they didn't report it, it was a $475,000 fine. Unencrypted devices. This was the Oregon Health and Sciences, and a laptop was stolen. The defense of the organization was they had done 6 security risk assessments, i.e. they had done that checklist thing every year like they were supposed to. The problem is, but because they had not done the correct administrative and privacy audits, or they had failed to identify that staff regularly took equipment off site. And the reason for the $2.7 million fine was the organization had lied. Okay, I'm sorry, the staff member not had lied. It was stolen out of a child's hands. So it was considered gross negligence. Why did you not know these things were going on? Malware. Okay. There was a organization recently, they did have a ransomware attack. Okay. Ultimately, they had to report it. When they reported it, what the organization was not angry about, the HHS was not angry about the malware. What they said is, well, you probably wouldn't have had this occur if you had done the correct risk assessments, not just security, and if you had had the policies and procedures in place to make sure your staff understood what they could and could not do, you would have avoided this risk. Now, by the way, these are the fines that were from the U.S. government. Usually 10% of the fines are what's called above the line. 90% of them are what's called below the line, i.e. it wasn't the $750,000 fine, it was the multi-million-dollar lawsuit. It was the cost of notifying all, I believe it was 11 or 12,000 patients that were affected. By the way, the average cost is $250 per patient. Okay, and you must notify all of them, so it can become very, very, very expensive. You could lose your license, you can lose your insurance, both cyber as well as the banking relationships you have. So you do not want to be dilly-dallying with this. You want to do this right, and you want to do this right from the very beginning. Okay, so HIPAA is good for business. Okay, separate of it being a legal requirement. And by the way, anyone who says that, oh, you don't really need to worry about all this, you can just do pieces of it, is dead wrong. The law is very specific. The 7 fundamental elements are what they enforce, and you do not want to be on the wrong side of that audit. Especially for ODs, HIPAA is a marketing opportunity. Being able to, having, documented showing to your clients that you're HIPAA compliant will make a difference. I'll talk, about, for example, Compliancy Group. If you use our platform, we will give you a seal of compliance. The feedback we get from what is healthcare, we've done different surveys of this, it will increase your conversion by 17%. There is a 17% more patients will come to you rather than go to somebody else. It will differentiate you from your peers and your competitors. You work really, really hard, right? Let's make sure that you can brag on it. Okay, this can help, as I mentioned earlier, with what is patient loyalty, employee satisfaction. You can use this in your online and social media strategies. It is all good for you. Okay, failing to do it is just, in my opinion, you are shortchanging yourself and your patients. If you don't believe this, by the way, one of the simple points we point is the stock market cares about this. So if you look at Fitbit put out a press release that they were HIPAA compliant. Their stock price went up 26%. Okay. Now, how simple is this? Compliancy Group is, as the endorsed solution for AOA, we want to show you just how easy the AOA has made it for you to do this. Okay, so that the way we look at it is the job that the AOA has asked us to accomplish for you is to first make sure that you have achieved compliance, and we give you compliance coaches to hold your hand through that process. 5 to 8 30-minute coaching sessions. Okay, once you've completed that, we make sure you have every report completed required to be able to prove that you are satisfying to the U.S. government. Okay, we give you the seal of compliance you can put up on your website. It's a true third-party verification and validation. If you get audited, we give you an audit response program, which means we will respond to your audits. Then going forward, everything that's required to maintain your compliance is built into the platform. So as I was showing you earlier, all of the 6 audits are required every year, full gap identification remediation plans, all the policies, procedures, and training, not just HIPAA, but fraud, waste, HIPAA, fraud, waste, and abuse, and PCI. Employee attestations, I showed you what we talked about, Dr. Golden. You also get full business associate management and incident management all built in. So we do highly recommend you speak to us. Now, I'm going to take a couple of the questions. Okay, so will we be sending slides to those people who attended the webinar? Yes, you will be getting an email with a link to both the recorded version of this and the slides if you'd like to download them. Please, like I said, this is just one of our many topics. We have other ones that qualify for continuing education. We have an actual full HIPAA 101 free training for your staff. So please do make use of that. Okay, let's read this particular one. Our office was contacted by someone claiming to be Our office contacted by someone claiming to be HIPAA auditor. They asked questions regarding our HIPAA compliance. Was this legitimate? Will HHS contact your office over the phone and then set up a time to call back to post questions? Absolutely not. Okay. There is an organization. I'm going to be polite and not use their name on this particular webinar. They have been issued cease and desist orders by both us, the AOA, OCR. They are impersonating or implying that they are HIPAA auditors asking you to participate in a free audit. If you get asked that question, basically tell them never call you again. It is against the law. It is misleading. What they are doing is they are implying that you have to do this because, let's say, you're tested for meaningful use, and therefore then you must attend one of their audits, and then they basically tell you have to pay them to get the answers. Okay, so no, do not do that. By the way, I do want to stress, if you do have any HIPAA-related question, if you go to the AOA website or the AOA Excel website, you will find our Ask the Auditor functionality. It is also on our main website at compliancegroup.com. If you go there, we will, whether you are a client or not, we will absolutely answer your HIPAA compliance questions. Some of them we may not be able to help you with because it may require more advanced requirements like a lawyer, but we will absolutely help you understand where you are and what you need to be doing. Okay, let's see the next question. What if you did answer their questions? This has been a scam perpetrated against ODs predominantly. There's nothing good or bad if you answered their questions, but then what is the most common practice is then they tell you have to, in order for you to find out how to solve the issues that were identified, you must have a call with them, and that they're going to tell you have to buy their services. So please, it is a very misleading way of working with our clients, and it makes me very sad that there is an independent organization that is being predatory on optometrists in the United States. Okay, so as we start summarizing this, getting HIPAA compliant is a good thing. It will ultimately save your money. It will help your patients and your employees get greater satisfaction. You do need to make sure you understand the entire nature of the rule, as does your staff. You should be updating your policies and procedures on an annual basis. The training of your employees, and like I said, if you're looking for free HIPAA training, it is on our website. You are welcome to download it. You still have to do all the rest of the things you saw outlined, but please. One of the real simple ones is do not be afraid to report a breach. Okay, most people think that, oh my God, they're going to come after me. But I can tell you, if you don't report it and they find out about it, and miraculously they do seem to find out about most of these, you are looking at now from what was a minor situation into being something that was considered gross negligence, or negligence or gross misconduct. So you absolutely don't want to do that. If you're interested in more information, please do feel free to contact my organization. My whole team will gladly do demonstrations for you. We have a whole bunch of continuing education free webinars. We will be speaking at several panels at Vision Expo West. We also speak regularly at PERC events. We do cybersecurity training for them. If you are a PERC member, please do come see us. It's a counts for CE credits. We are also doing a webinar special. If you contact us within the next 7 business days, and you are one of the folks that were registered on this webinar, you can save 25% of our services. So please take us up on it. All right. If there are, I'll give you guys a chance to ask me any other questions. If not, then I will let you all get back onto your busy days, because I'm sure you have places to be and patients to serve. All right, we didn't get any more questions. Do feel free, you can email them or go to info at Compliance Group or the compliance chat. I thank you so much for your time today. I really appreciate you for being a member of the AOA and participating in great educational events like this. So have a wonderful day. Thank you.